Here's the thing most people don't realize yet. California didn't just tweak a few firearm rules for 2026. It quietly rewired the entire system in ways that are already catching ordinary, well-intentioned gun owners completely off guard. And if you're not paying close attention right now, you could find yourself on the wrong side of the law without ever intending to break it. This isn't fear-mongering. It's the reality of how detailed and unforgiving these changes have become. Imagine waking up one morning, going about your normal routine, storing your firearm the same way you have for years, driving to the range the same way you always have, and then finding out later that something you did without thinking now qualifies as a criminal offense. That's the environment California gun owners are living in as of 2026. The margin for error has basically disappeared. What makes this year different isn't just that the laws are stricter. California has always been strict. What makes 2026 different is how precise, layered, and interconnected the new rules are. The legislature passed multiple measures that don't operate in isolation. They overlap, they reference each other, and in many cases, they turn what used to be a harmless oversight into a charge that can follow you for the rest of your life. Some of these changes didn't come with loud press conferences or bold headlines. Several of them took effect right at the start of the year, meaning they're already live. If you purchased a firearm late last year and didn't revisit your storage setup, your transportation habits, or your ammunition buying routine, you could already be out of compliance and not even know it yet. Let's start with ammunition, because this is where people are running into trouble almost immediately. Beginning in 2026, every single ammunition purchase in California is now subject to an enhanced, real-time background screening process. On paper, that might sound familiar, because California already required checks for ammo, but the new system is far more aggressive than what existed before. Previously, if you had a firearm registered in the state system, most ammunition purchases cleared quickly. Now, that's no longer enough. The updated process cross-checks your purchase against a wider range of databases, including recent mental health holds, restraining orders filed years ago, and misdemeanor convictions that may never have flagged you before. Even sealed or dismissed matters can cause delays while the system sorts things out. In real life, that means this. You're at the range. You burned through more rounds than expected. On your way home, you stop to pick up another box of ammo. What used to be a quick transaction can now stretch anywhere from several minutes to over an hour, depending on system load, and if anything in the database doesn't match perfectly, your purchase can be denied instantly. What's worse is that denials aren't always correct. Mistaken identity, outdated records, or clerical errors can all trigger a rejection. Once that happens, you're locked into an appeals process that can drag on for weeks or months. During that time, you can't legally buy ammunition. Trying again before resolving the issue isn't just pointless, it's dangerous. A first violation may be treated as a misdemeanor, or repeated attempts within a few years can elevate the situation into felony territory. Now let's talk about storage, because this is where many responsible owners are being blindsided. California has always emphasized safe storage, especially in homes with children or prohibited individuals. But the 2026 updates don't just say store safely, they spell out exactly how safe is defined. Under the new standards, a compliant storage device must meet specific state approval criteria. Not just any lockbox or safe qualifies anymore. The device must meet defined resistance benchmarks and prevention standards, and it has to be listed as approved by the state. If you're using an older safe or a generic locking cabinet, there's a real chance it no longer meets the legal definition of compliant storage. The rules go even further if you own more than a small number of firearms. Once you cross a certain threshold, the law now requires that your safe be physically anchored to the structure of your home using approved hardware. Bolting it down isn't optional anymore, and the type of bolts and anchoring method actually matter. Why does this matter so much? Because liability doesn't end when a gun is stolen. If someone breaks into your home and takes a firearm, investigators will examine your storage setup. If it doesn't meet the new standards, you can be charged even though you were the victim of a crime. And if that stolen firearm is later used unlawfully, the consequences escalate dramatically. There have already been cases where owners believed they were doing everything right, only to discover that a technical deficiency in their storage setup exposed them to criminal charges. Good intentions don't matter anymore. Compliance does. Now let's shift to carry permits, because this is where confusion is turning into arrests. California's concealed carry system has always been restrictive, but after recent court battles, the state responded by redefining where you can legally carry. The result is a long list of so-called sensitive locations where carry is prohibited, regardless of permit status. Government buildings are off limits. Schools are surrounded by expansive buffer zones that stretch far beyond the school grounds themselves. Places of worship are prohibited unless explicit written permission is granted. Medical facilities, including clinics embedded within retail locations, are included. And then there's the rule that's catching the most people by surprise. In 2026, California flipped the default assumption for private property. Carrying in a privately owned business is now illegal unless that business has clearly posted signage stating that concealed carry is permitted. No sign doesn't mean permission, it means prohibition. This is the opposite of how many other states operate, and it's leading to unintentional violations every single day. Walking into a store, cafe, or restaurant without realizing the policy can result in charges even if no one ever noticed you were carrying, and once cited, your permit is automatically reviewed. Many people are losing their carry privileges not because of malicious intent, but because they relied on assumptions that are no longer valid. Now consider the expanded definition of restricted firearms. California has maintained a registry for certain weapons for years, but in 2026 the criteria widened. The new focus isn't just on how a firearm is configured today, but on what the state believes it could be converted into. Under certain conditions, firearms that were legal under previous rules may now fall into a newly expanded category based on internal components or theoretical modifications. Owners of these firearms are required to register them by a specific deadline. Missing that deadline doesn't result in a warning or a fine. It results in felony exposure. The registration process itself is detailed. It requires documentation, photographs, serial numbers, and additional background screening. And if law enforcement encounters an unregistered firearm, that now qualifies under the expanded definition. The penalties are severe, including potential prison time, transportation. Rules have also changed in subtle but significant ways. Firearms must still be unloaded and locked during transport, but now ammunition handling is regulated more tightly. If you're transporting both a firearm and ammunition in the same vehicle, they must be stored in separate locked containers. Simply placing them in different areas of the trunk isn't enough if those areas aren't individually secured. This is leading to citations during routine traffic stops. A broken tail light turns into a vehicle search. A well-meaning explanation turns into a violation because of container placement. Confiscation, fines, and charges follow, all because of a rule many people don't even realize exists yet. Private transfers are another trap. The state now requires a mandatory waiting period for all private transactions, no exceptions. Both parties must appear in person twice, once to initiate the transfer and again to complete it. Missed appointments void the process, and improper transfers expose both buyer and seller to serious criminal liability. Then there's the expansion of firearm restraining orders. More people than ever can now initiate these petitions, and they can be issued without your presence in court. Firearms can be seized before you even know an order exists. Fighting it takes time, resources, and patience. And even a successful challenge doesn't guarantee a quick return of your property. Violating one of these orders, even unknowingly, is treated as a felony, and because the list of eligible petitioners has expanded, the risk of misuse or misunderstanding has increased as well. So what does all of this mean in real terms? It means that being a responsible gun owner in California now requires constant awareness. Old habits can be dangerous, assumptions can be costly, and silence from the state does not mean permission. The people who stay out of trouble in 2026 won't be the ones who assume they're fine. They'll be the ones who double-check, document, and adapt. They'll review their firearms, reassess their storage, rethink their routes, and update their routines, not because they want to, but because the legal environment demands it. California has made it clear that enforcement will not be forgiving. The penalties for mistakes are steep, and ignorance won't protect you. Staying informed isn't optional anymore. It's the only real defense left.